Good morning, all. We're here for a hearing in the matter CA 006-2019 before Chief Justice Zaki Azmi, Justice Judith Prakash, and His Excellency Justice Madhani. The appellant is represented by Global Advocacy and Legal Counsel. Lead counsel is Louise Wright. Assisting is Robert Whitehead. The defendant is represented by Baker McKenzie. Lead counsel is Mazen Bustani. Assisting is Andrew Massey.
Good morning, Your Honour. Might I just make a representation as a matter of housekeeping before we commence the application? And it's merely out of courtesy and an apology if I could take the court to the attempted skeleton argument at 1-149 of the e-bundle. And it is at page 9 of the skeleton argument, paragraph 31. That we have omitted a word that makes quite a difference. I will come to it in the substantive application. However, I feel it's right at this point to mention that what it should read at the bottom of page 9.
Page 9. Page 9, did you say?
Page 9 of the skeleton argument.
9 of skeleton argument.
Appellant's skeleton argument, right?
Of the appellants.
Yeah. Paragraph 31?
That's correct.
No, where is it? Okay, 31. Additionally?
It's document number 45.
Okay.
Sorry, what is the correction?
The correction is at, it should read, on the third line down, the sentence should read, as part of this, the claimant has provided an Aramex confirmation which includes a signature from the shipper and not from the receiver. So it's just that one word of not, that of course changes the context.
Makes a lot of difference, yeah.
I apologise to the parties for that omission. So, Your Honour,
Registrar, how do we correct this on the screen? Hard copy, I know, I write with a hard copy. How do you correct this? You can't correct this, it's PDF, isn't it? You have to.
You can make note now.
On my copy. On my copy. I can make note on my copy. Can you make note on your copy? Or put a note on can't do anything. Okay, let me take a note of that. I'm not very good with this thing. Para 31 appellant skeleton submission add in note. Okay. Okay. One. Yes, please.
thank you, Your Honour.
You had appeared before us last month or 2 months about a dispute of certain statements made by Judge Omar which you didn't like.
Yes, Your Honour, made a note of that.
The same. It's the same case, isn't it?
It's a different defendant. We're here
Different
for
defendant, but
the
same
case.
Case.
Yes, Your Honour, that's correct.
Okay. Before we proceed on, is there anything else you want to say?
In relation to that case or the housekeeping?
Anything else one has to speak?
No.
No, that's all. So before we proceed on, there are a few things we feel that we need some clarification to save a lot of time. And for that purpose, I would like to invite my sister, Miss Judge Judith Prakash, to you want to make some clarification.
First of all, I wanted to ask you, it's not quite clear to me what the defence, fifth defendant, proposes to put up.
The point of the application, Your Honour, is that in fact the appellant has not been given that opportunity to put forward a defence.
Yes, but 1 minute, please. He has not been given the opportunity because judgment has been entered in default. But when you apply for judgment in default to be set aside, generally speaking, you do give an indication, and you should, of what your defence would be if the judgment is set aside. So what is that?
In relation to the defence itself, there is, you will have noted again from the skeleton argument that a criminal case has most recently been filed in relation to this. But in fact, the criminal case links to a forgery. So the whole case is...
Sorry, is the criminal case filed against? Who is it filed against?
It's filed against the...
Plastic.
If I can just refer to my... I do have details of the criminal matter.
You know, you do have the glass to use if you want to drink. You don't have to act as if you're in a food court.
Okay.
Your Honour, it is Mr. Ahmed Abdul Qader Hamdan Zahran, which is not party to this proceeding. However, the second respondent in that forgery allegation is the first defendant in this case, Fast Telecom.
So is it, and what is the relationship between the forgery allegation and this case?
Well, this case was brought against this appellant in relation to a facility agreement.
Yes, I'm aware of all that. I have
Okay,
read
and
the
it is-
papers.
I'm grateful, but it is linked to that agreement that this appellant states that he was not given the opportunity or not provided the correct information prior to signing that agreement. Now,
Sorry, this appellant signed the agreement.
he did. He did sign the agreement. However, unfortunately, I am not familiar, and I don't act in the local courts, and I do not.
Yes, but
make
you should have your
representations.
client's instructions as to why he should not be responsible for this claim.
Your
If
Honour,
he
yes.
signed the agreement,
He signed the agreement.
Yes.
However, my point is that in relation to the criminal allegation,
yes, but you are the one who brought it up, so you must tell me how it is relevant.
it's relevant because although it's been signed, the laws of Dubai are different to, of course, the laws of England and Wales and certainly DIFC in relation to how that signature came about. And it isn't that he in any way was forced or under duress to sign the agreement, but the case, as I understand it in relation to the forgery, is that he wasn't given the appropriate information of the requirements that you must have when you're signing such a document in
Right.
accordance with the correct laws of the land.
Yes, so perhaps the person who did not give him the information is liable to a criminal charge in the National Court of Dubai, perhaps, because I don't know, you don't know either.
No.
But how does that affect your client's defense in relation to the bank? Is, under the law of the DIFC, is it a defense to say, I was asked to sign this by my colleague, I signed it, I didn't really realize what I was signing? Is that a defense?
What the offence is that the agreement will not be binding if it is found that the signature on that agreement is a forgery, a fraud.
But it was not a forgery. You've just admitted your client signed it.
But that's what I'm trying to explain, Your Honour, in relation to the forgery of the local
Is
criminal
that agreement,
allegations.
I'm sorry, is that agreement which is governed by the laws of the DIFC, quite clearly, yes?
Yes,
Is that agreement a nullity under the laws of the DIFC? Is that your defense? If it is,
it is. It
Well-
has to be that when the agreement was signed, it wasn't done with the requirements of the laws of the forgery.
no, please.
Let's get on. You keep on using the word forgery.
And I
Forgery means it's not my signature, is somebody else's signature or somebody signed on my part. That is forgery.
As I understand
But
it,
you also admitted just now that your client did sign the document. So if he did sign the document, it is not a forgery. Which is which?
which is how I interpret the law of forgery. I'll have these discussions with my colleagues.
Yes.
However, in relation to local legislation, forgery, and I have the actual case.
You are saying that forgery under the Dubai law,
Yes,
not forgery under common law.
correct.
Yeah, you are saying. But then Judge Judith Prakash asked you just now, is this agreement bound or subject to the English common law as applied in England, or is it subject to the Dubai law? That is the next question. If it is to the Dubai, if as way what we understand, my own knowledge of forgery is what you know you are signing the document. What is the term used? You know the signing the document is just the terms are you misrepresentation or something like
It
that.
is maybe you always argue that there is a misrepresentation of some of the maybe terms of the agreement or something like that, or references to the agreement.
I'm not sure I understand. I'm sorry. Could you repeat that?
I said, I think you might need to refer to misrepresentation of this, some of the terms or reference in the agreement, and instead of forgery.
Well,
I mean, at common law, this is not a forgery.
and I agree the
Yes.
interpretation
So
is
if
not
it's not a forgery, in common law, is it under the law? We are administering the DIFC law, which is basically common law. So can you say that the agreement is not valid?
I would say under common law, it would have been a misrepresentation, and potentially you have.
But
to have
misrepresentation
duress
you said there's no duress earlier.
in relation to the laws of the UAE. That does not exist.
I really don't understand you. Can you say very clearly what your client's defense would be if we allowed this appeal?
Yes. What would your defense be if we allow the appeal and set aside, you go to court for trial? What would be your defense?
Your Honour, I will answer that, but what I do want to highlight for the court is that this hearing was not, and the application has not been made in relation to making submissions on the defence that is available to this appellant.
No, but my sister just said to you that one of the grounds when we apply to set aside the judgment in default, one of the matters we take into consideration is your defense. How good is your defense? Are you likely to succeed at the trial? Is that the law?
Well,
It's quite clear in the rules of the DIFC that that is one thing that is taken into account. And your learned friend in his submissions has said that there is no defense and therefore it's no point allowing this appeal. So I would like to know, if we allow this appeal, is your client going to be able to put up at least an arguable defense? Or is it just going to be a waste of time and the end result would be the same as it is now?
well, at the risk of repeating myself, Your Honour, a claim has been filed in the local courts in relation to what they constitute forgery. I accept that in common law it's interpreted wholly differently when we talk about forgery. What we would potentially be talking about in common law would be misrepresentation or even duress. However,
Okay, let's go backwards. My first question, this agreement that your client was purported to sign, under what law is it subject to?
DIFC, which of course
DIFC,
does
which
not
is
have criminal.
English law.
It does.
Yeah, in common law, English common law,
But must adhere to criminal.
not Dubai onshore law, right?
Correct.
So how relevant is the Dubai onshore law in your defense?
Because it's a criminal matter and DIFC does not deal with criminal matters.
No, you go and get convicted in Dubai onshore law. We don't care about that. We are not talking about this agreement. How does this agreement become invalid or void or whatever and unenforceable because of what happened on onshore court?
Because if it is found that the signature is in breach of public policy, then...
And criminal law is, what criminal law are you talking about? If there's a criminal law, there must be a decree or a statute or something, not public policy, please.
It's forgery, Your Honour. That
Forgery.
is how the case has been filed.
Yes, so forgery must be somebody not signing. What is the law that is being relied on? It seems to me that you don't know anything much about...
I don't pretend to know anything about the criminal matter.
Yes, you don't know anything
But we're not
about
asking you about the criminal matter. We're asking you about your own substantive defense that would be available to you if we allow this case to go further and to trial. And we don't want to waste the court's time. And even if we granted you now permission to set aside, and then what you're going to tell the CFI judge next, why you're not liable? You know what I mean? This is our question. We didn't ask you about, we understand you try to raise something about forgery or you try to get rid of responsibility of that document. But this is, you gotta understand this court's point. What would be the available defense for you before the trial judge?
Yes.
What you're gonna tell him, why I'm not liable for this?
Yes. That's all. You answer that question.
I do understand, Your Honour. I do notice that, having been on my feet, I note that the lawyers who are dealing with the parallel matter that we are discussing have entered the room. I wonder whether the court would be minded to allow me 10 minutes to have a better understanding of what has been filed and how that can link to this case.
I'm very disappointed, you know. I'm very disappointed. Basic knowledge of setting aside of judgment in default is very, very, very basic. I learned that when I was a magistrate at the age of 25 in Malaysia. And for you to come and say that you are not aware. Anyway, if you want 5-10 minutes, we'll give you 10 minutes then. We'll take a 10-minute adjournment.
In relation to your point, if I may come back, I've not been permitted to make an application in relation to the set-aside application. My questions have been relating to the defence should matters proceed.
I start again. When we consider, this is an appeal that is pending before against the judgment of Judge Shamlan.
Yes.
Isn't it? This is an appeal, right?
Yes.
You want to set aside Judge Shamlan's judgment for not allowing you to set aside that judgment in default that he gave, right?
Yes.
Right? Okay. The next step is, before we decide whether to set aside a judgment in default, one of the matters that's important or that we take into consideration is whether you have a good defense. Right? Do you agree with me there?
Yes.
Yes. So we are asking you, what is your defense? That's all. That's all. And you brought in the subject of forgery. Fine. We can accept that. If your defense is forgery, we'll accept that. But you, at your own statement, also say it is not forgery. Now you relate that forgery to some criminal act that is supposedly to have happened in the Dubai courts. But the Dubai court do not apply English common law. We apply English common law and DIFC. So how could that defense of forgery in the Dubai courts apply in this territory? That is my argument, and you have not been able to answer that. That's all. Very basic.
Your Honour, but the basic application, as you refer to it, relates to the mandatory provisions of why a judgment should be set aside.
Yes.
And doesn't relate to the potential defence. We will submit that there is a realistic prospect of a defence.
Yes, but what is your defense? What is your defense?
It's part of our test. It's part of our test whether allow your appeal or not is to see your defense.
And
That's why we're asking you.
And the defence, as I understand, although that is not for the purposes of today. I appreciate you want an idea of what the defence would be. And my understanding of that defence is that the agreement would be annulled on the basis that the signature was on the agreement, which is the facility agreement, is annulled. And then
Is annulled. Annulled
basis,
under what law?
it would have to be in DIFC.
Yes.
It,
Tell me what is the law that will annul your agreement under the DIFC? Tell us that. Normally I don't lose my temper. But I'm getting very impatient. You appeared before me two months ago. Anyway, I think we'll take a 10-minute break. You understand what? If you are not clear, then your colleague or somebody else can explain to you. If you want the authority, I can produce the authority that one of the matters we take into consideration is whether you have a good defense. Not necessarily good defense.
An arguable defense, a reasonable prospect of success.
No, you cannot.
Something. You know, Miss Wright?
So, shall we take a 10-minute break for you to clarify us on that point? You want a 10-minute break? You want 10 minutes? Or you want to see? You want to do the consultation while we sit here?
I'm in the court's hands, Your Honour. I am happy to take instructions whilst we remain in court.
The question is very simple. What is your defense? Plausible defense. That's all that we want to hear from you.
Yes.
What is your defense? But if you don't have that, then as we repeatedly say, even if we allow this judgment in default to be set aside and the case goes on for trial, there is no likelihood that you will succeed. That is why we want to know what is your plausible defense.
Yes, I understand your question, Your Honour. Again, I just, at the risk of repeating myself, the application is made under the mandatory provisions that the judgment was entered in error.
So are you talking about in error because of procedural non-compliance or what?
Yes, Your Honour, in relation to the fact that there has been, I'm sure you're aware, a catalogue of errors, procedures, parallel...
No, please. What is the error that you specifically rely on in relation to the entry of the judgment? Catalogues are not relevant.
Well, Your Honour, how would you want me to proceed? Would you like me to make the application in full, or do you want me to give you a summary of...
Perhaps a summary. I mean, first of all, the question is, what was the error in the entry of the judgment? And for that, I'm sure you can give me a one-sentence answer.
Absolutely, Your Honour. It relates to the fact that the appellant in this case was denied...
I'm sorry, I don't see that you can say somebody is denied. Judgments in default are entered all the time, and the procedure provides for that to happen if the defendants don't do certain things. Now the question is, was it a wrong use of the procedure in this case? Not in relation to denying him a chance to give his defense, but was the procedure wrongly applied?
Yes.
And which part of it?
There was no acknowledgement of service. The default judgment was entered prematurely.
As far as I can see, the only argument really that you have is the default. But if there was no the premature point, if there was no acknowledgement of service, then was it premature?
Yes, because the time for entering default still remains. The appellant in this case still has time to put
Well, maybe
forward
you
a
can
defence.
maybe you can give me a chronology. So when was it served?
There's quite a lot in this case, as you are likely to be aware.
What was the date of service?
The date of service, Your Honour, was the 19th of October 2017.
And when should the acknowledgement of service have been entered?
Yeah, there was also on the 3rd of October that the claimant filed his particulars dated the 3rd of October. That's seen at 155 of the e-bundling. And thereafter filed a certificate of service for the particulars dated the 19th of October.
All right, so the certificate of service was the 19th of October.
The certificate of service stated that service of the particulars had been effected on BSA law firm, who at the time purported to represent the appellant, on the 3rd of October 2017. On the 22nd of October, the claimant filed an application for a request.
As far as your client is concerned, was the document ever served on his address for service?
Absolutely not.
No?
Absolutely not, Your Honour. And the reason I mentioned and referred to a catalogue of errors in this case is that there were formal complaints put forward against BSA by a number of the defendants in that case, and were actually found by the Deputy Registrar to be in breach for purporting to represent the defendants in this case, of whom the fifth defendant was one.
My honest view is that your strongest point would on premature entry of judgment.
And that is our
Can you give the dates? Can you give the dates? I'm looking for the dates here. What is the premature entry of judgment? I was looking at it.
The 29th of October, Judicial Officer Nasser issued the order, and that is at 157 of the e-bundle.
26, paragraph 26 of Appellant Skeleton's argument at page 8 of 12. You did mention here claimant's position that particulars were served. RTC, the earliest time the claim would have therefore been entitled to apply for default judgment against 28 days after service of particulars on the. You are saying that they failed to comply with this requirement.
Exactly, and that is if it is taken that BSA were even served in relation to this appellant, which our case is that, of course, they never did represent them, so particulars were never served in any event.
Sorry.
However,
can I get back to my question, please, for a minute, which is, did the respondent serve the claim on BSA? I know BSA entered an acknowledgement, or did they serve it on the address for service?
they served it on the BSA. There is also notice that it was sent to an email address, which the claimant in that case linked to this appellant. However, it is our submission that that email address, the appellant did not have access to that.
But that is not for the bank to know.
Respectfully, Your Honour, the appellant in this case was no longer a shareholder in the company.
That may be
and
so.
by virtue,
Yes. What did the agreement say about service?
the agreement itself states that there should be, and I can certainly read it verbatim if it would assist, but the agreement does state that the parties are to notify any change of address.
Which your client did not do.
Because there was no change of address, they served it on the incorrect address.
I'm a bit confused. You see, there are 2 points here. One is your point about prematurity.
Yes.
But that, to an extent, only applies if BSA was appointed, which they were not. Right? I mean, on the basis that they were appointed, then the judgment was premature. But if they were not appointed, then it goes back to a question of whether your client was properly served in the first place. And so what does the service provision say in the agreement?
My friend is just locating that for me, but what I do want to say on that point, perhaps of more relevance, respectfully...
I'm sorry, if I ask you a question, don't tell me something else which you think is of more relevance. Please just answer my question.
And my friend is just...
Yes, so please find it.
Can you read paragraph 29, your skeleton? The claim form pertaining to the proceedings provides an address at Al-Warga Street. At paragraph 12, his witness statement, the appellant confirms this is not and never has been his address. At no point did he receive a copy of the claim form. Further, the claim form provides an address of Hormodi Fastel. The appellant has confirmed this is no longer his email address, and he was blocked by the first defendant prior to him selling his shares in the first defendant's company.
Correct.
Right?
Yes.
Is that your answer?
It is.
But my question is, what is the address provided in the agreement for claims to be served? What is the address? Is it at Arwarga Street 35? Or is it a different address? I'm sorry, I think we seem to know more about the case than you. You don't seem to be... This is prepared by you. There are a lot more things, unsatisfactory things happening in this file, which I'm not going to go into. But it caused me a lot of confusion trying to understand. But you don't seem to know. Okay, what is the address that is provided in the agreement? The agreement, what's the address? There is an address. If there's a claim, you're supposed to be served at this particular address. What is the address in the loan agreement?
Well, maybe you need to refer to clause 2 of the agreement, which is in document number 37. Document 37. Ali, you may share that. No, 37, 28, 1.
37, 28, 1, what is it?
Yes. Number 2.
This is 130.
115.
Which one is? There's so many numbers. Which one are we using? The red one?
It's on the right side. This one.
The red. In consideration for you granting, I understand, Ibrahim, Comoros, Al-Warqa Street, number 35. I mean, it's going to agree to it on later. Yeah, but where is the provision which says that in case at the end, normally it's at the end. There, page para 15. For the purpose of first demand limited personal guarantee, I elect domicile at the following address, Arwarqa Street 35. And that's what the bank did. You cannot accuse the bank of not serving it properly if they comply with the address, unless that you have notified your change of address.
Which wasn't. I believe it's accepted that although there's an incorrect address also in the agreement, service. There was no service of the documents.
Why? What is your authority for saying that? If the address, how would the bank know that this is the wrong address? You tell me.
Well, Unfortunately, it links back again, at the risk of aggravating the court, but it links back again to the point of this appellant that he was not given the opportunity of reading any of the documents prior to signing, and therefore, unfortunately, was not made aware of the incorrect address.
Yes, but the person who did not give him the opportunity, as I understood his witness statement, was a gentleman named Mr. Osman, or Oman? Osman.
Osman.
Yes, and Mr. Osman worked for the borrower, Fastnet. He wasn't an employee of the bank. If he was an employee of the bank, of course, your position is very clear and useful. But he was Fastnet's employee. So you can't relate that back to the bank, who would not have been aware.
But the point is that there was no service of the documents. It's accepted that the address that the documents were served to is the same address that is in the agreement.
And where is the law that says that if you serve at an address which is stated in a document and accepted as an address, that is not a good service?
Your Honour, unfortunately, we take your point on that.
Mm-hmm.
But the fact remains.
You agree with me, in case of dispute, I serve on a certain address, I comply with that requirement of the agreement. How can you say that's not sufficient compliance?
Because, of course, I just revert back to the fact that this appellant was totally...
So that is not your defense? Wrong address is not your defense?
It is.
It is not. You are using the criminal fraud as the ground, as your defense.
Well, that was in relation to the question of the defence, in
Yes.
relation to the application.
Yes.
Our point is that
Yes.
there has been no service, and the service that was put forward, the address that was put forward for service by the claimant, is incorrect. I
Okay.
accept that it is the same address that is in the agreement, but we revert then back to the appellant's point that he was never given the opportunity, which he should have been, of reviewing the agreement prior to signing.
But not by the respondent. I mean, I'm sorry, but I don't understand this argument. He must have a better defense than I did not read it because my friend just told me sign it and I signed it. I mean, that is sheer carelessness on his behalf, on his part.
There is a principle in English law which says that if you are signing a wrong document which is not related to what is it? There is some principle I can't remember. You know, so.
I mean, if you sign it under a mistake and you think it is a tenancy agreement and it turns out to be,
that's what I mean.
This is mistake, you're talking about mistake. It turns out to be a guarantee, then you can say, I did not know what I was signing and I shouldn't be held liable. But he signed it. He says he did it in a hurry. After that, he looked at it and he realized it was a guarantee, but he didn't go back to the bank immediately and say, no, I didn't mean to sign this, give it back to me.
Well, he didn't go back to the bank, but as he refers to in his witness statement, he did go back to the company and ask for various documents in relation to what he had signed and why, and he came unstuck.
Yes, I understand that. So he may very well have a very good claim against Mr. Osman and the company who deceived him. But does this deceit of the company allow him a defense against the bank?
It is our case that it does.
And your authority?
Again, I would have to ask the court for time in relation to that. For today's purposes, our application was very much focused on the mandatory provisions of the errors in this case.
No, sorry, what mandatory provisions? Which rules of the DIFC rules are you looking at?
It's 14.1, Your Honour, and again in relation to the fact...
Sorry, I couldn't hear you. Could you repeat that, please?
Sorry, in relation to Rule 14.4, which goes to the reasoning of the order in that the appellant in this case had not adhered to the formalistic requirements of that rule, when in fact he was not given the opportunity, and that is our case. That he did provide the supporting evidence by way of his witness statement.
Refer to 14.2. Oh, sorry, can you remind me the reference to RDC?
14.4.
Yes, but you must look at 14.2 first, which is the grounds on which a default judgment may be set aside.
Yes,
And 14.2 says, number one, he has a real prospect of successfully defending the claim, which so far, I'm afraid, for me at least, you haven't shown. Or secondly, it appears to the court that there is some other good reason why the judgment should be set aside or varied, or the defendant should be allowed to set aside the claim. So have you got any other good reason?
it would relate to the submissions in relation to the particulars of claim, the fact that the appellant in this case was not represented by BSA as had been reported. There was no acknowledgement of service, there was no particulars of claim, and he hadn't been given the opportunity to put forward that defence.
So the appellant was not represented by BSA, and therefore?
And therefore there was no acknowledgement of service filed. No particulars of claim were filed.
The particulars of claim were filed but not served on him?
Well, they were filed, but they were not served for reasons that they were served on BSA, who purported to represent this appellant, which of course is denied. And also going back to the fact that they were served up to the incorrect address, albeit I take the court's point in relation to the address that is in the agreement.
You're saying the address within the agreement is the wrong address, or the courier wants to a wrong address rather than the one mentioned in the agreement? I didn't get your point.
We accept that the address in the agreement is the same address as the claimant states that he, in fact, served the necessary documents. However, it is the appellant's case that has never been his address.
Oh, it's not his address at all?
It's not his address at all, no, never has been.
You mentioned something about mandatory requirements. What are the mandatory requirements?
Your Honour, in relation to 14.1, it provides 3 instances when a judgment in default must be set aside. Yeah. And in relation to that rule, we refer to the first 2, which state, in the case of a judgment in default of acknowledgement of service, any of the conditions in Rule 13.4 and Rule 13.6 are not satisfied. Okay. And if
what are they? What are they? Expand on that.
The court to those, 13.4 states that the claimant may obtain judgment in default of an acknowledgement of service only if the defendant has not filed an acknowledgement of service or a defence to the claim, and the relevant time for doing so has expired. Well, of course, it is our case that we have never received an acknowledgement of service, and the case that, therefore, for filing a defence has, by virtue of that fact, not expired.
I'm sorry, can you say that again?
So, it
seems to me it says, the claimant may obtain judgment in default of an acknowledgement of service. So was this a case of a default of acknowledgement of service? You would say yes, because BSA was not authorized.
Correct, Your Honour, yes.
So, only if the defendant has not filed an acknowledgement of service, your client did not file an acknowledgement of service, correct? And the relevant time for doing so has expired. So when would the relevant time for doing so expire?
Well, the relevant time for doing so would expire by virtue of the fact that particulars in this case were filed. It would be 28 days after that.
And where the 28 days comes from?
Rule.
Yes.
Sorry, I believe it is rule. .9. The general rule is that the period for filing a defence is if the defendant files an acknowledgement of service under Part 11, 28 days after service of the particulars of claim.
Sorry, you're looking at 16?
16.9.
So, now if the defendant does not file an acknowledgement of service,
Which is not your case.
And Your Honour, in relation to the same matter under Part 11,
I'm sorry, can we go back? What is the period within which a defendant must file an acknowledgement of service?
14 days
14 days after service.
after service.
And if the defendant does not file an acknowledgement of service within those 14 days, then what happens?
They apply for default judgment.
Right. They don't. Do they have to file a particulars of claim before they do that?
No.
No. So isn't that this case?
I'm sorry, I don't get your point.
The service was done on whatever address on, what was the date? 17th of October?
Of October.
2017. So 14 days after that, which would have been the beginning of November 2017, your client should have filed an acknowledgement of service.
Yes.
Yes. And he didn't do so.
No,
Right?
because he didn't receive the document.
Yes, but he didn't do so. Whatever the reason is, he didn't do so. It's just going by the rules. So since he did not do so, could they not have filed a default judgment at that stage?
Technically, yes.
Yes. So why are you talking about the time not having expired? I mean, if you're relying on Rule 13.4, then the time expired a long time ago. It's only if you rely on Rule 13.5 that you can say they were premature.
Which we have as well referred to in our skeleton argument.
But then you now say that acknowledgement of service will bind you. It's a bit difficult, isn't it?
Well, Your Honour, we have never received the documents. So
Yes, I do understand all that background, please. Your client's case is he didn't know what he signed, or rather, he knew what he signed later. He didn't do anything about it. He didn't check anything. He never went back and changed his address. And so when service happened, he wasn't told. He found out later because there was a warrant of arrest for him. But if we just go by the rules at the moment, if you say that BSA was not authorized to represent him, then no acknowledgement of service was filed and the time expired. On the other hand, if you just take the BSA acknowledgement at face value, you can say, I suppose, now let's hear what your learned friend says, that they didn't wait for the expiry of the 28 days. So that's your point, isn't it?
yes, it is.
Thank you.
Anything else?
Not unless the court have any questions, I think, in relation to the provisions in which we make the application. I have already exhausted those upon your Honour's inquiries. Your Honour, do you have any questions in relation to the application?
We'll hear the respondent. We'll hear the respondent. can you go on this premature entry of judgment first?
Yes, of
Me,
course,
that's-
Your Honor.
yes.
And in fact, I would rely on the judgment of this particular court on the 11th of June and on sections, I don't know if you have the judgment before you, but on sections 22 to 30, in fact, the court has dealt at large with this issue.
Have you filed that? Have you filed that piece of paper that you're referring to?
It's not filed.
How can I know? How can you refer with the you did not file?
That's true.
Why? I'm so unhappy with the things done. Plaintiff, if you read through your notice of appeal, the first paragraph is a mess up because you're talking about application for permission to appeal. It confused me a lot. And then I concluded that there were a lot of typing errors there. I had to sort out and say, no, this cannot be an appeal for permission. But if you read through that paragraph, sounds like that. You know, I had to go through and say, no, this is. But this is not very unprofessional, extremely unprofessional. How can we refer to a document we shouldn't have a copy for us?
Mr. Bustani, are you referring to the default judgment?
No, I'm referring, Your Honor, to the Court of Appeal judgment dated.
Oh, an authority, you mean?
Yes, dated 11 of June.
And you didn't file that?
Is it part of this e-bundle?
No, he said no.
No.
Anyway, read and see what it says.
So, in sections 22 to 30, in fact, this particular court deals with the prematurity
Section or paragraph?
paragraphs 22 to.
So which case is this?
He didn't
This
have a
is-
copy
this-
for us.
This case?
This particular case
Against which defendant?
Another
against
defendant?
the second and the third defendants.
This is Sir Jeremy Cook's judgment.
You are referring to Jeremy Cook's judgment. Only one copy. Huh? I'm quite aware of this. I've read through. I was on the panel. You and I were on the same panel. Yes, go ahead. Read.
So whereby the judge, whereby this court, Your Honor, deals with the issue of particularity of judgment and the service of the particulars of claim, and after which period it should be filed. And the court concludes that it should be served after 14 days of the particulars of claim, before concluding at paragraph 2019 that the application to enter judgment in default of defense was thus made 5 days after expiry of the time for
I'm
service.
sorry,
of-
could you read this? I haven't read it before,
sorry.
rather than summarizing it.
Yes.
Thank you.
I will read it, Your Honor. It was argued, though the judge...
So you're starting at paragraph
22, Your Honor.
22, right.
Yes. It was argued, though the judge did not determine the point that the application for default judgment was premature, because the time for service of a defense did not elapse until 28 days after service of the particulars of claim, on 3 October 2017. The application for default judgment was made on 22 October 2017, some 19 days after such service. Despite the claimant's apparent acceptance of the proposition that 28 days was the relevant time limit for the defense to be served on a proper construction of RDC, it is in fact only 14 days which must elapse following service of the particulars of claim, where they are served separately from the claim form. The 28 days period applies only where the particulars of claim are served with the claim form. The rules draw a distinction between the position where the claim form is accompanied by particulars of claim and the situation where it is not. RDC 10.1 sets out the position where the claim form is not so accompanied and gives a defendant the option to admit all or part of the claim or file an acknowledgement of service in accordance with Part 11. See in particular RDC 10.1.3. RDC 10.2 sets out the position where particulars of claim are served and gives a defendant the option to make admissions, RDC 10.2.1, and or file a defense, RDC 10.2.2, but RDC 10.2.3 specifically provides that where particulars of claim are served with the claim form, the defendant may file an acknowledgement of service in accordance with Part 11. It is plain that RDC 10.2 thus draws that distinction between the two situations where the claim form is accompanied by particulars of claim and where it is not. RDC 11.2 provides that the defendant should file an acknowledgement of service when the claimant serves a claim form without serving particulars of claim, whilst RDC 11.2.2 provides for acknowledgement of service to be filed if the defendant is unable to file a defense within the period specified in RDC 19.9, which of necessity can only apply where particulars of claim have been served. RDC 11.2.3 requires an acknowledgement of service where the defendant wishes to dispute the court jurisdiction. RDC 11.5 provides that the general rules is that the period for filing an acknowledgement of service is 14 days after service of the claim form. When reference is then made to RDC 16.9, it is clear that provision is there being made for this distinction between the situation where particulars of claim accompany the claim form and when they do not, notwithstanding that it set out general rule for the period for filing a defense. The rule provides, the general rule is that the period for filing a defense is 14 days after service of the particulars of claim.
Right, so if you go on then to paragraph 26,
Yes.
The judgment says 14 days, which applies. In a case like this was exactly the same particulars as what happened for the fifth defendant?
Yes, I'm sorry.
Yes. Yes.
So, whilst the rule is not a model of clarity,
No, I don't think you need to go on.
yes.
Right, so you established, you said 14 days,
Yes,
so 14 days would...
So the default judgment was entered correctly and correctly.
Continue the rest of your submission.
Yes. Furthermore, so in addition to the above, obviously the application for appeal was made outside the appeal period, which is 21 days. The appeal was made 1 year after the order of Judge Shamlan Sawar was made. The appellant is arguing that there was a call between a certain Mr. Fadi from the company, from Fast Telecom, arguing that matters are settled, to argue the delay in applying for the appeal notice. However, the rules do not give grounds for any period outside the 21 days, and thus we respect.
So the time for filing a set-aside application expired when?
Expired
The judgment was entered on
22.
13th January 2019.
29 October. The default judgment was entered on 29 October 2017.
No, you're talking about now the time for permission to appeal, isn't it?
Yes.
Wait, 1 minute, sorry. The default judgment was then 29th of October,
Absolutely.
2018.
217.
217.
2117.
And the application, and so
The first-
and therefore the time would expire when? 31 days?
1 month.
Rough. So what is it?
There are no time frame in the rules for the set-aside application.
No time frame.
No time
No
frame.
time.
No time frame.
All right. So then the set-aside application.
The first set-aside application was filed on November 2017.
2 weeks, I think, something like 2 weeks, I think. No, 2 weeks.
2017? This set-aside application was 2 weeks later?
The first set-aside application.
No, this set-aside application.
This set-aside application was...
For this defendant,
For
not the other defendant.
No. For this defendant,
Yes.
he filed first on 13 November 2017.
13th November.
13th November.
2017, the first set-aside application, and his set-aside application was rejected by the order of Judge Shamlan Sawal on 14 January 2018.
2018.
But
okay.
the filing was 2 weeks after the judgment was entered
Yeah,
into.
13 November.
So not very long.
Not very long.
Right.
However, he applied for another set-aside application on 6 January 2019, so 1 year later.
Well, I don't follow that part. He applied again to set aside.
He applied again to set aside on 6 January 2019.
The first application, who handled it?
It was handled by the defendant person.
Personally? The
Personally.
first one.
First one.
And the second one?
It was handled by our learned colleagues. And it was made on 6 January 2019, so 1 year later. And it was rejected on the grounds of Rule 4410 that provides for 21 days.
Why did they file it again? I missed that part. Why did they file again 1 year later?
Why?
I missed that part. Yeah, but can you apply twice for the same thing? Can you apply twice for the same thing?
Miss Wright, maybe you could answer that question.
Why was the second application to set aside filed?
On the basis that the order of the judge was that he was denied for formalistic requirements which our cases were satisfied, and therefore that...
I'm sorry, I don't understand. The first one was handled by your client in person.
Yes,
And it was rejected.
it was.
And once it's rejected, what you do is you appeal. Right? He didn't appeal.
No.
You filed a second application.
Yes.
Wasn't that res judicata, abuse of process, etc., etc.?
I wasn't involved in that procedure.
Yeah,
I
but did you know?
apologise.
No. Did you know that he had filed the first one?
I believe it was known to us.
Then how do you justify filing a second one instead of perhaps applying for leave to appeal out of time?
In relation to the procedures, I cannot answer that question.
Okay, anyway, he filed the second one. Of course, it's res judicata.
It was rejected.
On the
Then,
ground?
On the ground that it was already rejected.
Res judicata.
Yes.
Yeah.
And then they filed a notice of appeal to your Excellency.
So the notice of appeal, if calculated from the first judgment in default, application to set aside, would be 1 year plus.
1 year plus. The notice of appeal came in February 2019, and Your Excellency, the Chief Justice, granted the notice to appeal on 27 February 2019.
Okay, on the other issues that she has raised?
On the other issues, obviously, Your Honor, this is an everlasting saga. Applications for arbitration, applications, code of conduct complaints, forgery complaint, 2 full years into the proceedings, an alleged forgery complaint filed to the Dubai courts, knowing very well that this will again delay the proceedings because the way the Dubai courts work, and you know quite well. Although I was a bit confused by the skeleton argument because it looked like the forgery complaint was filed against my clients. They mentioned that it was filed against the respondent. However, it turns out that it was not against the respondent, that it was filed.
So the forgery complaint, who is it made against?
I'm not aware.
Not against your client.
That's what we just
The first defendant, yes.
However, in the skeleton argument, it is mentioned that it is against the respondent.
Can I ask you, there are 5 defendants.
Yes.
What is the status of the action against the 5? The first defendant?
The first defendant, we have commenced enforcement proceedings against it. However,
You have judgment.
we have a judgment. That
So
was
one
not-
judgment
Yes, against the company, the borrower.
Against
Yes,
company.
absolutely.
and enforcement.
And enforcement. However, the premises are closed and we are not able to enforce against
Then
it.
the second and third defendant?
The second and third defendant I filed, although we, just to evade submitting a defense into substance, have submitted an arbitration application.
No, have you got a judgment against them? Second and third?
No, we have not. We don't have any judgment against them because the default judgment was set aside, and they were supposed to file defense pursuant to the Court of Appeal decision dated 11 June, and they submitted arbitration applications.
So default judgment was set aside.
Yeah.
They were supposed to file defense.
Contest of jurisdiction, yes.
Yes.
For 2 and 3.
For 2 and 3.
And for number 4?
The fourth defendant, Mr. Al-Masrouai, we have a judgment against him. We have an immediate judgment against him. However, we have received an order from the court to wait for a month before starting enforcement proceedings from the date of the immediate judgment. We have received from the DIFC court a letter stating that we should wait for a month before commencing enforcement proceedings.
But he never showed up, isn't it?
He showed up.
He did show up,
Yes,
yes.
and he was represented by Al-Alam, if I'm not mistaken, and we have an immediate judgment against him. The fifth defendant is Mr. Hormodi, and the sixth defendant has never showed up, Mr. Zahran.
Who is this? Yeah, Ahmed Abdul Qadir.
Zahran, yeah. Who has never showed up.
And the second and third defendant, just to come back to them,
Yes.
they did not file a defense, and
They never filed a defense.
and they have filed an application for arbitration.
Yes. Despite the clear wordings of the judgments of the Court of Arbitration.
And this application for arbitration has not been heard yet.
Not yet. Really delaying that.
After that, they will apply to go to JGC.
I doubt that because there are no grounds for Dubai courts.
That's what you say.
In any of the
You should see some of the file that
I
matters.
know
They go.
that, unfortunately.
Is there anything else you want to say?
No, furthermore, as we have raised in our skeleton arguments, the terms of the guarantee are very clear, and there are no grounds for defending or prospects for defending this claim. Therefore, we would seek.
Okay, Ms. Wright, you want to reply?
I will just come back on 2 points, if it will assist.
Yes.
The first being in relation to the criminal allegation, and I can confer by the assistance of those sat behind me that this respondent is in fact the third defendant in that case.
Third defendant in
In the criminal matter.
Who is he?
That's Bankmed.
Bankmed, okay. Bankmed, okay. And then the next one?
And the other point, if it assists the court, is it's just in reflection to my friend's mention of the period of delay between the two applications, and the reason being, as mentioned in the skeleton argument, is that following the dismissal of the first application, the appellant was approached by Mr. Fadi of Bankmed and was told not to worry about anything, matters had been taken care of, and that now he was no longer involved in the company, there would be no action taken against him. And he perhaps naively took his word on that and thought matters had gone away, and as we've already...
Sorry, when was this? Mr. Fadi is supposed to have approached him?
That was during the course of the following few months, in fact, of the dismissal of the order, that he was told it didn't matter, it had gone away. And
Which dismissal of which order?
In 2018.
The first...
January 2018.
After the judgment in default has been entered?
Yes, but he wasn't aware of that at that time.
Oh, I see. I misunderstood again. I thought that representation was made before the judgment in default was given.
No, he was told not to be concerned.
Yeah, but that is after the judgment in default was entered in
That's correct.
2017.
That's correct.
So how does this fact help your client?
How does what, sorry?
How does this fact help your client?
It is merely to try to add flesh to the bones of my friend's point in relation to the accepted delay in the next application being made in 2019, when he then came to Al Umran, in fact, who sits behind us today, when he alerted them to the fact that he'd been made aware through making applications for travel visas that in fact an order against him had actually been made. He was not aware before that.
No, I'm sorry, I'm confused. The judgment was entered in 2017.
Yes,
And then 2 weeks later he applied to set it aside,
correct.
and he failed in January. He was told January 2018 that was rejected.
He was naively took...
No, sorry, that was rejected.
Yes.
And after that was rejected, the bank officer said, don't worry.
Yes. It was Mr. Fadi.
From First Telecom,
Yes.
not from the bank.
From where? Where was he from?
First
From
Telecom.
the first defendant.
Well, you said from the bank.
No.
That is why we were all confused. I'm sorry, was this gentleman from the bank, or was he from the first defendant?
He was from Fast Telecom, the first defendant. I apologise if I missed
Yeah, Mr. Stalin?
Yes, but this shows that absolutely the fifth defendant was aware of his guarantee and was bound to it, since he was told not to worry, which means that he was indeed worried, and that he knew that he was bound by the guarantee.
Yeah,
have you
but-
started enforcement proceeding against him?
Yes, pursuant to the default judgment, we started.
That's it for his second application then?
That led to his
say
second
so.
application 1 year later, Your Honor.
Oh, I see. In between the first default judgment
Yes.
and the second, the first application to set aside and the second application to set, you proceeded
Yes.
with enforcement.
Absolutely.
I see.
And in fact, to say that he was not aware is somehow because not only the judgment was published on the DIFC court website, but it was also published in the gazettes in Arabic to all the defendants pursuant to the enforcement proceedings in the Dubai courts. In May 2018, if I'm not mistaken.
Anything else, Ms. Wright?
Nothing further.
Shall we adjourn over? We take a short break.
precisely.
Yeah, I do. I go to the gym quite a lot when I'm in the time. It's like we kick boxing. So yeah, it's kind of
That's good.
Trying to bring G7.
Yeah. Just
Some pictures here.
I'm for
Progressive. But no, we can, we prefer that paper. This is my normal one.
against immigration.
Yeah, we need to travel.
All rise.
I'm going to give you brief reasons why we arrived at this decision, but we will give a more comprehensive, complete judgment later. Basically, there are three main points that I'd like to raise just for this, but it would not stop me or the court from dealing with other matters in the more complete judgment later. First is on the issue of the judgment being prematurely entered. We regret that the judgment of Jeremy Cook, of which I was on the panel, and I must confess, I forgot that part of I was I remembered more about the argument was that statement made by Judge Umar should not have been, you want to appeal against that. But I forgot about this part of it. So to that extent, I apologize. But I would have expected counsel for appellant, who was also counsel in that case, would have brought this to our attention in the first instance. And I think it could amount to a breach of ethics not to do so. Secondly, again, reading from the skeleton, we didn't realize that there were two applications to set aside. One made 1 year later, which is in fact a res judicata. Why that was made, we do not know. I would like to say that had you applied to set aside or appeal against the first judgment to set aside, judgment entered and set aside was made 2 weeks prior, maybe you stand a better chance to have it set aside, but not in these circumstances. And thirdly, plausible defense. We've gone through at length on the possible defense. We cannot see if there is any possible defense at all. For those three basic, briefly, our reasons, we dismiss the appeal with cost. Do you want to say anything on cost before we pick the order for cost, Mr.?
Absolutely, Your Honor. We would like the fullest extent of the cost.
Pardon?
The fullest extent of costs.
What's that?
We would, the claimant...
I know, but what is that? You want to be assessed by the registrar?
Assessed by the registrar, but this has been ongoing for 2 years, Your Honor, and the client has been bearing a lot of costs due to the delay and delaying tactics that have been pursued by the defendants.
Ms. Wright, you want to say, you agree to cost being assessed by the registrar?
Yes, if we could be given the requisite time to respond fully to the application for costs.
What is there to respond? Of course, we make an order that cost to be assessed by the registrar. I'm not going to constitute another panel just to hear on cost. We'll make an order for cost in favor of the respondent to be assessed by the registrar unless agreed between the parties. Right? Is your client here? No. I wish he's here because I would have liked him to hear for himself how his case will be conducted. Okay, if there's nothing else, I'll adjourn the court. Thank you very much.
All right.
Thank you.